some time as we go through it today.
Wait a minute, Greg, pardon me, but it's already 9:30 and I've taken time out of my day to be here. I'm the only person in my company that can make decisions. How long is this going to take? I've got meetings all afternoon that no one else can be there for.
This is exactly what I'm talking about. You don't even get it. This is why we're here today. You were so busy the day of the accident when you were talking on your cell phone, ran right into my car, no, because it's still the same thing. You were so busy the day that you rear-ended me that you didn't have the time.
Let me interrupt you
Yes,
for a
sir.
second.
I'm sorry.
I'm glad everybody's talking, and I want to hear your input on this. But one of the things that's very important about this process is that we don't interrupt and let people go ahead and finish their say. Let me answer your question, Tom, about the time commitment.
For the next 30 minutes, our mission is to make you as comfortable with and prepared for the mediation process as possible. Chances are you're scheduled to appear at a mediation with your lawyer and the other parties and their lawyers in connection with a lawsuit. Or you may be attending a mediation as a result of an employer-sponsored mediation program. Despite the huge success of mediation and its wide use and support by our courts, you may be attending your first mediation. Our hope is that this videotape will make you much more comfortable with the mediation process. The mediators at the Lakeside Mediation Center have mediated nearly 3,000 disputes and have worked with literally thousands of people just like you. Your own lawyer will give you important advice regarding your goals in your particular dispute, and you should value your lawyer's advice. We will walk you through the mediation process so that you will know how the process works, what the mediator does, and how you and your lawyer will participate. You know, the good news is that we know nationally mediation is successful in resolving over 75% of all disputes. As a result, the mediation is a very important step, and you stand a much better than average chance of resolving your dispute.
What is the mediator's job? What does the mediator do? A mediator is not the judge or jury. A mediator is not there to decide who wins or loses, or to even take sides. The essence of the mediator's job is to remain neutral throughout the process. What a mediator is really trying to do is to enhance communication between the parties and their counsel in a way that makes the parties search for a settlement of the dispute that everyone can live with. A mediator cannot force or coerce the parties to settle a dispute, and the mediator is not present to judge any of the parties. The mediation process is confidential. In almost all instances, the mediator may not be compelled by subpoena or otherwise to testify as to anything anyone has told the mediator during the mediation process. This is to allow the parties to communicate freely and openly with the mediator.
Your mediator is attempting to create an environment that will permit negotiations to commence, which will hopefully end in a settlement. Toward this end, the mediator will reality test all parties, usually in private meetings, to make sure that all sides are looking objectively at the good, the bad, and the ugly of their case. The mediator will also attempt to identify the underlying interest of the parties and to find out what the parties want out of the process and what things are important to each party. The mediator will work the parties through impasses. The resolution of conflict is not always easy, and the process requires patience, good communication, and often creativity. What many participants like about mediation is that the parties themselves, be they individuals or institutions, have a direct hand in determining the outcome or resolution of the dispute. For the next 10 minutes, let us walk you through the stages of the process. While some mediators may approach the process differently, you will find that things generally unfold like this at a mediation. Greeting the parties. Joint session, mediator's introduction, opening presentations, information gathering, separate caucus, reality testing, negotiation, memorandum of agreement, closure.
Good morning.
Good morning.
Heidi Obama-Vida.
When you arrive for your mediation, you'll be greeted by a receptionist. Usually, You'll be escorted into a private room with only you and your counsel until all the parties arrive. The mediator or a receptionist will then escort all the parties and their counsel to a conference room for what is called the joint session.
Once everyone is seated, the mediator will ask each party to introduce themselves and indicate in what capacity they appear at the mediation. For example, a party might say, "My name is James Smith, plaintiff in the case." The purpose of these introductions is to make sure that the mediator knows who everyone is, as well as the other parties. Once the introductions are made, the mediator will make a mediator's introduction, which will last about 10 or 15 minutes.
A mediator's introduction is designed to accomplish several things. Most mediators begin with a brief discussion of their background and qualifications, so the parties, who are often meeting the mediator for the first time, have a better idea who the mediator is.
My role in this process is to serve as a neutral. I'm not going to be the judge, I'm not going to be the jury, I can't twist your arm or force you to settle the case in any way. My job essentially is to foster communication between you and your counsel and the other side and see if we can't find some common ground to settle this matter today.
The mediator will then explain his role to the parties so that the parties will better understand the mediator's job. The mediator will explain neutrality, confidentiality, and then provide a preview of how the process will unfold. The mediator will often explain the benefits of the mediation process and set some ground rules. Such rules might include a no interruption rule and asking the parties to address each other in a civil manner. The mediator may finally ask the parties for certain commitments. The mediator might ask whether the parties are there with full authority to resolve the dispute, or the mediator might ask if all the parties are willing to give the process a good chance to work.
I can't really say at this point how long today is going to last. I'll have a better feel for that when we get into independent caucus, but I think it's important for you to remember that whatever time you spend here today is a good investment. It may take us all day, but it certainly won't take us the weeks or months that a trial will take. You have an opportunity to dispose of this dispute in one day, and I'd like everybody's commitment that they're going to stick around for as long as it takes today and give this their best shot at trying to reach a settlement.
Of course, the time involved pales in comparison to the days, weeks, months, and even years of pretrial matters and trial. And the mediation process takes place in a private, comfortable setting. You should check with the mediator and your counsel regarding dress, but comfortable business casual dress is usually appropriate, and you should make contingency plans if the session continues into the evening. So what happens in the joint session after the mediator concludes his introduction?
At this point in the process, I'd like to hear from each of you about how you view the dispute. Generally, at this point, we'll start with the person that brought the claim.
You know, opening presentations at mediation are different from opening trial statements. Keep in mind, the purpose of mediation is to reach a resolution and not to persuade or influence the mediator. One of the true benefits of mediation is it provides your lawyer with his only chance to speak directly to the other side and for opposing counsel to speak directly to you. You will be afforded an opportunity to speak at the joint session, but that is a decision that you and your lawyer will make before you arrive. Usually the mediator will ask the lawyers on all sides to make opening presentations.
Mr. Schmidt, I know that going through a lawsuit is, for both sides, a very daunting and painful process at times. This is my one opportunity, sir, to be able to sit down with you, with your lawyer present, perhaps before this case is going to be tried in a few weeks, to discuss whether there's any opportunity for us to get this resolved. The case is relatively simple, as you know from your pre-mediation submission. It's my client stopped at a red light, an automobile accident case where she was rear-ended by the defendant. In this particular case, it's been our allegation, and that it's very clear that at the time of the accident, you're using the phone. It's undisputed that you were talking to a corporate client at that time, and you told the police officer at the time that you were distracted by the cell call.
Cheryl, why don't you respond to that as the defense lawyer? Tell me how you see the defense of this case going.
I'd be glad to. We're not really here to dispute the liability issues. Our issue is the damages. We have seen medical records totaling approximately $15,000, but the demand in this case is, I believe, $350,000, and in our view, that is excessive.
These presentations usually take 10 to 30 minutes per lawyer, and your lawyer's tone will likely be conciliatory. This is not a sign of weakness, but rather the tone is consistent with the very nature and purpose of the mediation process. The lawyers on all sides are really attempting to do two things. First, the lawyers who want to make sure that the mediator understands the dispute. More important, each lawyer wants to make sure that the other party appreciates the extent and the nature of their risk. When the other lawyer is speaking, you will likely not agree with what that lawyer is saying, but this is not a trial. Opening presentations are not to be interrupted, and it is essential for everyone to at least listen to what is being said, attempt to walk in each other's shoes a bit, and utilize these presentations to objectively evaluate the dispute. The lawyers on all sides, because it is a mediation, should be courteous, respectful, and civil.
After the lawyers have made their opening presentations, the mediator will ask each party whether they wish to add or contribute something during the joint session. Again, you should discuss with your lawyer whether you should speak at this moment. If your lawyer encourages you to do so, then you will have an opportunity to express your feelings about the dispute, and this may be your only chance to directly address the decision makers on the other side.
What really bothers me about this whole thing is that I was sitting at the red light, completely stopped, and looked up in my rearview mirror and saw this guy coming straight for me with a cell phone in his hand. That's, to me, I knew at that point that he was not even paying attention to the red light and was not even going to try to stop. And all I could do was brace myself for the impact. I know it happened so quickly, and at the same time it's like slow motion to me. And I relived that through all of the time that has passed and all of the work that I've had to go through to try to regain my health. And I guess I just want some type of acknowledgement of the fact that it's not just the money at all at this point. I think that it's also acknowledging the fact that I was injured and that it was his fault and that he was conducting company business when this injury happened. That's what's bothering me about this whole thing.
The fact is, it's a car accident. I'm sorry. I feel terrible about what happened. I tried to find you in the hospital and make sure that you were doing okay. I was not able to determine where you were in that hospital. I truly feel bad for what happened. But your lawyer has demanded a totally unreasonable amount for this car wreck. He's asked for $350,000, and he's trying to hold my company responsible for this. This is a car accident. This is not company liability. I've built that company from scratch. Now, y'all may not understand what that means, but I put my sweat and blood into that company, and there are other people who depend on that company for their livelihood. And listen, just because I was using a cell phone has no bearing on the damages in this case. I think it's absolutely despicable that your attorney has come in here asking for $350,000 when the medical expenses add up to $15,000. I just don't understand it.
While you may need to express some difficult and personal emotions, your tone should be, if at all possible, respectful and civil.
I did spend several days in the hospital. I was transported by EMS. I've had a lot of physical therapy. I've gone through missed time at work, not just in the days after the accident, but in time that I've had to take doctor's visits, time off for physical therapy. I've had pain in my back and in my neck. I've not been able to do the things that I would have normally done.
Tom, would you like to add anything at this point?
I sure would. Listen, I am sorry for what happened. It was an accident, though. I didn't intend to hit you. I was on a cell phone, but let's get real. Cell phones are a reality today.
Keep in mind that the mediation process belongs to everyone, and you play a very important role. As your lawyer will tell you, strong feelings aside, A fair settlement is always in everyone's best interest, yours included. Occasionally, after everyone has spoken, the mediator may ask some questions to clarify points and issues. This is part of the information gathering process.
After the joint session, the mediator will likely split the parties and their lawyers into different rooms. This part of the mediation process is called the separate caucus or private caucus.
Now that we're in our separate caucus, I want to remind each of you that everything we say in this room is going to be confidential. I won't say or repeat anything in the other room that you tell me here unless I'm specifically authorized to do so. So this is your chance to really open up. Tell me what's important in this case to you. It's okay to reveal any weaknesses or concerns you have in your case. It's our chance to sort of flesh out some of those issues and really kind of bring them out into the daylight and take a good look at them without fear that the other side is going to see them.
There will be many separate caucuses during the mediation, and the mediator will be moving back and forth from room to room in a form of shuttle diplomacy. Typically, and check with the mediator in your case, everything discussed during the separate caucus will be completely confidential, not to be disclosed to the other side unless you permit such disclosures. As a result, your lawyer will likely encourage you to speak freely and openly with the mediator during the separate caucuses. This will allow the mediator to understand what is important to you and your candid assessment of both the strengths and weaknesses of your position.
Let me remind y'all that when we're in this private caucus, everything we talk about in here is going to be held confidential. I'm not going to tell anybody in the other room anything we talk about unless you authorize me to do that.
Keep in mind that the mediator is not there to judge you or declare whether you are right or wrong. The mediator is not your lawyer or there to give you legal advice. But the mediator will reality test all sides.
Tell me what's at the heart of the conflict for you. Let's learn about it from your perspective. I think we're making progress in the other room. I have a good feeling about us being able to resolve it today. But let's go ahead and flesh it out a little bit so that I can understand exactly how you view this whole thing.
During reality testing, the mediator will ask open-ended questions which permit you and your lawyer to more critically and objectively evaluate your positions. As your lawyer has no doubt told you, no case is perfect, and every case has its good and bad points.
What sort of counterproposal do you want to develop? What message do you want them to hear in this?
Well, it's hard for me to respond to that, Greg, because I made an offer, as I pointed out, on behalf of my client that we do have room to negotiate in. But it's really hard for me to try to formulate a strategy to respond to an offer which is so ridiculously low, not commensurate even with any reasonable recognition of her damages.
You should remember that the mediator is not just reality testing you, but he is reality testing all sides so that all parties may objectively evaluate their risk and so that constructive negotiations can occur.
At the close of the first separate caucus, the mediator will solicit your first settlement proposal. This begins the negotiation phase of the process.
But, you know, it's really not my place, Tom, to tell you what's a good move and how it'll be received in the other room, but am I hearing you authorizing me to take that back in as a counteroffer?
Sure.
Okay. Let me go ahead and do that then, and I'll come back and visit with you after I've had a chance to deliver your counterproposal. I understand that that offer is probably not going to be acceptable to you, Terry, but what sort of counterproposal do you want to develop? What message do you want them to hear in this?
All the things that I say in here are confidential, right? You're not going to tell the other side what I'm saying. I'd really like to get this case settled. This is an entire year of nightmare out of my life. I've just gotten married, and my new husband and I are about to buy a house. I'd really like to get this thing over with and start my life. I feel like there's a stopping point from the date of the wreck to now, and if I can end this today in some way with a reasonable settlement, then I'd like to do that.
In many respects, a mediation is a supervised negotiation with the mediator acting as the traffic cop of the negotiations. Mediation is a process and negotiation is a process. Negotiations often take time, and you should expect several rounds of proposals and counter-proposals during the mediation process. Negotiation may often be frustrating, But keep in mind that what matters is where the negotiations end, not where they begin.
Mediation is, by its very nature, a flexible process, and the mediator will make procedural determinations depending upon the situation that develops. For example, a mediator might decide, after splitting the parties into separate caucuses, to call for a second joint session to allow for additional direct communication. In the appropriate case, a mediator might wish to host a lawyer-only caucus to discuss a legal issue. Or, and only with the permission of counsel, a mediator might want to bring the parties together without the lawyers. The flexibility of the process, unlike the rigidity of a trial procedure, allows for greater creativity.
As we've discussed, a mediator may not force the parties to settle. But if the parties do reach an agreement at mediation, the agreement will be reduced to writing in something called a memorandum of agreement. Typically, the mediator will prepare the first draft of the memorandum of agreement and will present it to all the lawyers and parties to review for form, content, and accuracy. After all the suggested edits are made and agreed to, the mediator will present a final draft to all parties and counsel for signatures. To complete this process, I'm going to hand it to each of you for your signature, and this will be a fully binding agreement. The dispute will be resolved. Congratulations. In virtually all states, a signed, mediated agreement is an enforceable agreement and may be enforced as any other contract might be. Simply put, once the parties and their counsel have signed a memorandum of agreement, it is binding. After the mediation, the lawyers will also prepare the final release, dismissal, and settlement documents that will be filed with the court and which will reflect the agreements set out in the mediated agreement. Well, Tom, Terry, congratulations. I hope you're happy.
Thank you.
After the mediated agreement is signed, the parties may want to get together for a few minutes to exchange handshakes and wish each other well. This is referred to as the closure phase of the mediation process. In fact, after a resolution is reached, the parties often feel a sense of relief and may desire to exchange a gesture of conciliation. A mediator will not force you to do this, but will usually ask if you wish for an opportunity to say goodbye and extend mutual wishes of goodwill.
Let's take a few moments to discuss some of the most frequently asked questions about mediation. Eric, what are some of the primary advantages to mediation?
You know, Greg, I think there really are three special advantages to the mediation process. First, the parties have the unique ability to craft their own resolution to their dispute instead of abdicating that responsibility to a judge or jury. Second, the mediation process is by its very nature creative. The parties are not limited by rules of law or procedure to arrive at an agreement that makes sense to them. And finally, I think it provides parties with an opportunity to gain closure on very difficult emotional problems, and in some instances, actually gain conciliation, which is very beneficial to how people feel.
Can a mediator force a party to settle?
Absolutely not. The mediation process is not designed to be coercive or forcing anybody to do anything they don't want to do. By its very nature, the mediation process is consensual. The parties reach an agreement if they want to. To be sure, the mediator will encourage all sides to move towards an agreement, but a mediator can simply not make anybody do anything that they don't want to do.
If one party is convinced that they're right, isn't a trial the best place for them to find justice?
Greg, the answer to that question is that ultimately, if you go to trial, it is true that a judge or a jury is going to make a determination that someone is right and someone is wrong. The reality is that before you get to that trial, no one really knows who is going to be found right and who's going to be found wrong. In a mediation, it's not a matter of who is right and who is wrong. It is a matter of negotiating a settlement to end the dispute.
If the parties reach an agreement during the mediation, can one side back out of the agreement?
If an agreement is reached and signed by all the parties during the mediation, it becomes a binding agreement between or among the parties.
What should the parties bring to the mediation?
You might want to bring a notepad and something to write with. during the mediation process. Additionally, you might want to bring something to read, books, magazines, newspapers, and the like, something to do while the mediator is meeting and conferring with the other side.
Is there a court reporter present at the mediation?
There is no court reporter present at the mediation, and at a mediation, the parties aren't really giving testimony. This is not a deposition, it is not a trial. The mediation process encourages people to speak openly and candidly, and in fact, no record is made of the mediation itself.
How should the parties address the mediator?
Well, you certainly don't call the mediator Your Honor, because the mediator is not a judge. Most mediators at the very beginning of the process encourage and ask if it's okay for everybody to refer to each other by first names. Alternatively, Mr. Jones, Ms. Smith would be an acceptable way to refer to a mediator, but not Your Honor.
Finally, what happens if the case does not settle during the mediation?
In many instances, even though the case doesn't settle at the session itself, sometimes within days or weeks after the session, the matter does in fact resolve as a result of the mediation process. In other instances, the issues between the parties are narrowed, and even though an agreement is not reached, it reduces the number of days for trial. Finally, mediators as a general proposition continue to follow up on cases and encourage the lawyers and parties to continue their discussions, very often resulting in a final settlement of the case. We hope that you now have a better sense of what will happen at mediation and will be more comfortable with the process. You know, mediation has become a national and international approach to resolving conflicts. We think this is true for many reasons: avoidance of delay, minimizing costs, and reducing risks. But beyond those conventional reasons, it just makes sense for individuals and businesses to find better and more humane ways to solve problems and resolve conflicts. It's difficult to quantify the value of peace of mind or achieving conciliation, but we know such things are important to people. We wish you a positive mediation